Hi, in this video, we are going to be taking a look at the Murdaugh family murders. In particular, Alex Murdaugh had asked the court not to require him to wear shackles in court. Now, this has already been decided, but we're going to go back and see exactly what it was he was arguing at the time. We are going to pull up the motion that he prepared and filed for in support of his request. All right, let's see. This is State of South Carolina versus Richard Alexander Murdaugh. Motion for defendant to be unshackled in the courtroom. Defendant Richard Alexander Murdaugh, through undersigned counsel, hereby moves for an order requiring the state to unshackle him during court proceedings in which news media are present with video cameras. The U.S. Supreme Court forbids shackling criminal defendants during trial absent a special need. The law has long forbidden routine use of visible shackles during the guilt phase of a criminal trial. It permits a state to shackle a criminal defendant only in the presence of a special need. And they've got a case here that they're citing. Because shackling is an inherently prejudicial practice, it should be permitted only where justified by an essential state interest specific to each trial. This rule also applies to jury selection. So they've got a couple of cases here, and let me go back and mention one thing because you probably caught it when I said it. I did get a little thrown by that first sentence. You probably noticed that. The mention of the news media, I think, was a bit interesting. I hadn't expected them to start with that particular phrase. Let's look back at it again. Let me read that one more time, because my thinking was you were concerned about it being prejudicial for the jury, not news media. But they start off with this whole piece about to unshackle him during court proceedings in which news media are present with video cameras. I was surprised by that statement. All right, let's bring it back up so that we can get on to the next piece. It says something that was what they decided to start with first. I'm not sure what it says. There is no specific special need to shackle Mr. Murdaugh in the courtroom. He has not and is not alleged to have engaged in any behavior suggesting he is a threat to the courtroom or will somehow escape it. Security measures should be adopted to prevent disruption of the trial, harm to those in the courtroom, escape of the accused, and prevention of other crimes. And that was from State v. Tucker. In all the cases in which shackling has been approved, there has also been evidence of disruptive courtroom behavior, attempts to escape from custody, assaults or attempted assaults while in custody, or a pattern of defiant behavior toward corrections officials and judicial authorities. The fact that Mr. Murdaugh is charged with murder cannot be a special need justifying shackling. If it could, every murder defendant would always be shackled every time he is in a courtroom, but that is not the law. Most of the cases holding defendants cannot be shackled at trial, absent a special need, were murder prosecutions. Deck was a murder prosecution, so was Hayward, so was Tucker, so was Duckett. Even after a murder conviction in capital case, the defendant may not be shackled in the courtroom before jury proceedings are complete, absent a specific need. And that was from Deck, saying courts cannot routinely place defendants in shackles or other physical restraints visible to the jury during the penalty phase of a capital proceeding. From Utah and Young, the mere fact that a jury convicted a defendant of first-degree murder is not a sufficient basis for a decision to shackle him during the penalty phase. So let me stop there for a second, because that's usually the first thing that people sort of jump to and sort of think. They think, oh, but isn't it enough that this person is sitting in the courtroom having been accused of killing two people? But they're correct when they say, but that would take away the whole special need, because then that would be everybody who is accused. You're like automatically assume that you're some sort of threat, that you're going to possibly disrupt or assault someone just because you've been accused. Remember, at that point, you haven't even been proven guilty. And then they talk about the jury proceedings. And even at that point, stating that absent some special need, yeah, that this is not what generally has been supported. The interesting thing is, though, I'm going back still to the first sentence. They started with talking about the news media, not the jury. I am just not sure why they thought that that was the best sentence to start with. But oh well, we will go back and see what they say next. Maybe they're getting to the jury part, and I just haven't gotten there yet. Before a presumptively innocent defendant may be shackled, and let me make sure you can actually see it. Okay. The court must make an individualized decision that a compelling government purpose would be served, and that shackles are the least restrictive means for maintaining security and order in the courtroom. And they've cited United States v. Sanchez/Gomez. It says, on this point, the decision by Judge Newman regarding shackling the defendant in State v. Mahdi is instructive. Mahdi was a capital murder case in which the defendant had embarked upon a 4-state crime spree. After fleeing police at a gas station in Calhoun County, murdered a law enforcement officer at his home, then fled law enforcement again while armed with a semi-automatic rifle. During the prosecution, a functioning homemade handcuff key was found in the defendant's pocket, which he had smuggled into the courtroom in his mouth. The prosecutor and sheriff therefore asked the court to have the defendant's hands shackled. Even with that specific threat of escape, the court declined to have the defendant's hands shackled, reasoning that the sheriff was aware of the issue and would be able to keep the defendant from escaping without shackling his hands. It says, Judge Newman asked for input from both the solicitor and defense counsel. Solicitor Pasco agreed with the sheriff and endorsed shackling Mahdi's hands and legs and using any means possible to make sure the courthouse is secure. Judge Newman then instructed the sheriff, at this point, I will certainly agree that security is imperative. I believe that if you would use the leg irons in addition to the chains, but at this point, I would not want to have him shackled in presence of the jury with his shackles being visible due to the effect that this may have on his right to a fair trial. We'll step up the measures, and if anything further happens, I'm sure you'll be on top of it and we can address it from there. Thank you very much. There is no apparent reason why a more stringent rule should apply to Mr. Murdaugh, who has not evaded law enforcement, attacked law enforcement, attempted to escape from law enforcement, or engaged in any activity threatening law enforcement or court personnel. Mr. Murdaugh surrendered when first charged with crimes, and he was released on bond. And when he was released on bond, he complied with every condition of his release. He has threatened no one, and no one had to search for him. Thus, in this case, shackles are not the least restrictive means for maintaining security and order in the courtroom, and no compelling government purpose would be served by Mr. Murdaugh, the courtroom. I feel like they left something out there. All right. So let me just stop there for a second. So they use this case where this other person not only, was evading law enforcement, then brought a key in so that they could get out of the courtroom. And even then there was concern about the visibility of these shackles in front of the jury and whether or not that would harm the defendant's right for a fair trial. So if there's no government purpose, no compelling, I think it's important to say, no compelling government purpose, if you have someone who is trying to get out, on the opposite side of that, what they're saying is, well, no, not really, because look, we got a courtroom full of sheriff deputies in here, and it's a courthouse. He's got to get out of the courthouse, and then how's he going to flee? So they were making a case that, hey, the sheriff can handle it. And we just don't think it's fair for him, in order for the jury, to see him with these shackles on. All right, let's go back to the last piece here, where it looks like they're going to be talking about the opposition. Okay, so the defense has filed this motion asking for him to come to court without having to wear these shackles. And it says, in opposition to this motion, the state will argue murder defendants in South Carolina are always shackled in pretrial court appearances, and that Mr. Murdaugh should be no different. It is true murder defendants are typically shackled in pretrial hearings, but that is irrelevant. Most murder defendants do not have TV crews filming every pretrial hearing. Those who do, like Mr. Murdaugh, have a constitutional right to be unshackled unless there is an articulatable security issue specific to the individual defendant. The issue is how the court allows the defendant, in this case, to be displayed to the jury pool in advance of jury selection, not even-handedness regarding the relative physical comfort of criminal defendants across the state of North Carolina. So, okay, so I just made it clear that I live in North Carolina and not South Carolina, right? So, yeah, here's the thing, so first of all, they're trying to preempt what the state is going to say. And actually, let me open this back up so we can talk a little bit closer. So by putting in here what they think the state is going to say, they're trying to preempt that and say, hey, Judge, look, I know this is what the state is going to say. This is business as usual with shackles in pretrial hearings, but that doesn't necessarily make it the rule and what we need to do, because actually there's no compelling government interest here. And just because we've always done it that way, and the state's going to say we've done it that way, and it's that way across the state, that doesn't necessarily mean that that's how we do it here, especially when we haven't selected a jury pool yet. And everyone's going to be looking at this because there's been such media hype around this. And that's how they bring the media back into this. So this is not necessarily about him being in front of the jury yet. This one was about, hey, even before we get a jury, we want him to appear as a defendant a person who has been charged, not a person who is already guilty because he looks like someone who should be in prison, because look at him, he's got shackles on. So that was their argument. Now, the judge took all of this into consideration, because I'm actually talking about this a couple months later. The judge took all of this in consideration and pretty much, sided with the defendant on this and said, hey, I'm not going to require these shackles to continue to be placed on the defendant while he's appearing here. And the judge knows it too. There are already cameras in the courtroom looking at everything that's going on. And so that can impact what the jury thinks about the defendant before they ever even get selected and before they ever even see a piece of evidence in this. So this is one of those things where, when you go back and you think about it, you understand why a court would say, hey, yeah, let's go ahead and consider taking those off. And there have been cases before this where there's support for that action. So that's where we are in terms of the shackles. So if you see some older videos with him in shackles, and then you see some courtroom proceedings where he doesn't have shackles, now you have an understanding of what went on, how they got to the with shackles on to with shackles off, and why the court made that decision. So if you got something out of this video, go ahead and give me a thumbs up, please. Don't forget to subscribe, stick around. We're going to go into more detail about the Murdaugh family murders. Peace.